Okay, good evening, everybody. We're going to start this evening's webinar on mandatory reporting. Thank you all for taking time out of your busy schedule to attend or listen into this webinar. Of course, it can go towards your CPD, and it is appreciated that you attend these. It shows a real thirst for knowledge in the profession. So for those of you who come to other webinars, you'll probably recognize my voice. My name is Cara Moroney. I'm the Director of Professional Conduct. And with me is Ryan Pastana, our Communications Analyst, to assist with the webinar and the moderating. Normally we do have a practitioner with us to assist, but mandatory reporting isn't so much of a daily practice issue the way that record keeping is. So I think I can handle this one on my own. And as always, please feel free to type in questions at any point. There will be a bit of time at the end for me to answer your questions. And if you have any burning questions after the fact, you can always email me personally. So today, there'll be some objectives for today's webinar. At the end of the webinar, it would be good for you to know your obligations regarding mandatory reporting, to know when and how you should make a report, and then to understand the process by which the college will address those mandatory reports. And then we will the session's kind of broken up into two themes, and about halfway through, we'll break into understanding the relationship between mandatory reports and the new bylaw aimed at increasing transparency. And this is with respect to findings of guilt or convictions, is a little bit of a more recognizable term. And then finally, throughout the whole presentation, we want for everyone to appreciate the importance of mandatory reports, protecting the public interest, and ensuring confidence in the profession, and how mandatory reports ties in with that. So as I said, we will break the webinar is broken up somewhat into two different themes. I will talk more briefly about the types of reports you have to make and how. And the second theme will be about transparency, and this will be a little more in-depth. Also, with respect to the new bylaw, there is the consultation is still open, and it's open until May 26th. So if after this webinar you would like to make a comment, please feel free to do so. Okay. So why are mandatory reports important? Well, for the college, they are a very important source of information, which the college must receive in order to protect the public. Colleges don't go looking for information. We're not in hospitals, we're not in clinics, we're not in fitness centers. We can't be there seeing everything. So we really rely on the public for complaints, and practitioners, employers, facility owners for other information. We are required, though, that when we do receive reports, to respond appropriately to them. Mandatory reports, as opposed to other types of reports or complaints, are meant to capture the highest risk behavior. That is essentially why they are mandatory. The other part of mandatory reporting is that for you as a regulated health professional, you are conducting yourself according to your legislative duties, i.e. you will be following the law. But you are also demonstrating your professionalism. So it's very important to understand at the outset that when you're making a mandatory report, you are not ratting out. This is your duty to report unsafe behavior. And it's very important to build that understanding and culture in this profession. And especially when the profession is so new, it's good to get off on the right foot, of course. We want the profession to be mutually supportive of one another and inspire excellence, but when someone's behavior rises to too high of a risk, professionals really need to act. Then the other duty of self-reporting, when sometimes you have to report something about yourself, is important in the idea that you've been given the privilege of self-regulation. So reporting yourself or someone else can be a very apprehensive action, but not reporting and being found out later holds greater repercussions. And it's important to note that not all mandatory reports will result in regulatory action, or some might result in some type of regulatory action, such as an investigation, but not all will result in disciplinary action where your license may be suspended or revoked. There are some that do, of course, and we will come to some examples later. And just, it's important to remember that as the profession gains awareness, remember that, you'll have more scrutiny on you that others might report you. So better to be a profession that governs yourself and earn that public trust. Okay, so that is why, mandatory reports are important for the college, and a little bit about yourself, but more about how do mandatory reports impact you in the profession. So we want kinesiologists to build a professional esteem and pride amongst the whole profession, and that sometimes will require ensuring the regulator is aware of those that are falling below the standards. And in others, it is necessary to get rid of the bad apples, because everybody knows that saying, one bad apple can ruin the whole bunch. So when you look at this picture, the focus is on the bad apple. The eye is naturally drawn to that one bad apple, despite the perfectly fine one surrounding it. So the practice of all kinesiologists affects your own, because it's about building a good reputation. Now let's say that kinesiologists have a rare opportunity. You are a new regulated health profession, and it's up to the members to decide how you will be viewed by the public as you gain more recognition. I'm not going to list some of the professions right now that might have positive or negative images, but think about some professions that you know of that might have a positive or negative image, and how that might affect your own interaction with those professionals. We can never prevent all bad apples, but how a profession responds to those less than savory practitioners can make all the difference. So this is your opportunity when you're new. So what are your obligations? This slide is about the reports that you as an individual kinesiologist must make regardless of your role. So regardless of whether you're a manager or an owner, etc. These are reports made by you. So you must file a report with the college if you suspect that a patient has been or is being sexually abused by another regulated health professional. If your partnership or corporation or association in which you are a shareholder has ended because of professional misconduct, incompetence, or incapacity. You have been found guilty of an offense, and you have been found to have engaged in malpractice or negligence. So this would be a civil suit. Now, there are obligations to report for employers and facility operators as well. So this may not apply to you as a kinesiologist, but it is important for you to understand what your employer is obligated to report about you. These reporting obligations may be very applicable to KINs in non-clinical roles, as these often, not always, but often comprise areas of management, supervision, and oversight. And it's important that KINs in these roles take on that leadership and take on the responsibility of filing reports when they need to be made. It's not an easy thing to do, but that is part of being a leader and part of being a manager and part of establishing that reputation and culture in this very new profession, or very new regulated health profession. So many of the obligations are fairly similar to the individual KINs. There's the sexual abuse, and there's the dissolution of a partnership or health corporation. But then there's also termination, which is a unique situation between employer and employee. And also if an employee quits because they're facing a termination or disciplinary action, you need to report that as well. Basically to capture, people can't get out of that. So employers need to take on that responsibility. And the last one is if they have reason, if an employer or facility operator has reason to believe that a regulated health professional is incompetent or incapacitated. So you'll notice that this is one of the major differences between reports made by KINs and reports made by employers. This is in part to ensure that members don't start reporting everything to the regulator, or possibly creating a culture, of more tattling type situations. But it also reflects that sometimes an employer or a facility operator is in a better position to assess the overall picture of a regulated health professional. So for example, incompetence is not usually a one-time event, but a series of events or trends that may demonstrate a deterioration of a practitioner's skills and knowledge. So it's important that you as an employee bring these types of issues to an employer's attention, but the employer needs to be the one to address it. And again, for those KINs in non-clinical managerial roles, when you have employees coming forward to you and, complaining that they think someone is always showing up late or not getting the proper consent from clients, those aren't mandatory reports for the KINs. It's really important that you pay attention to those and be able to monitor employees that require it. And then if it results in any kind of reasonable belief that it's something more serious, that you step up and report it. Okay, reports of sexual abuse. This is obviously one of the most serious and most important reporting duties that you have. The philosophy is a zero tolerance philosophy for sexual abuse in the healthcare context with an aim to eradicating sexual abuse. So in order for you to understand your reporting obligation, it's very important for you and the profession to understand the full breadth of the definition for sexual abuse. It is not just sexual assault like we think in the criminal context. It's much broader than that. And so you don't wait until the most extreme sexual abuse happens. You can report any of these, you have to report any of these behaviors that fall under A, B, or C, and you'll see that C is behavior or remark. So that's quite broad. I will say that, and if you were at the Professional Boundaries webinar, you'll remember that we did stress that often sexual abuse starts with small breaches of professional boundaries. So, maybe thinking about a client or staying late with a client, commenting on their appearance. Now, that may be behavior or remarks, but it might not be. So while breaches or minor breaches of professional boundaries would fall outside of this definition of sexual abuse, I want to raise the idea that it's important for kinesiologists to step in when they might see these situations arising before anything worse might happen. The person that is having these boundaries blurred or is struggling with a client that they are overstepping the boundaries may need your support, and they may be aware that this is happening, but they're afraid to admit it, and they may be relieved to have some intervention. So always better to err on the side of caution. And as regulated health professionals, this means taking on the responsibility of ensuring the whole profession is meeting standards. So it may be uncomfortable to approach someone in these types of situations, but it is your ethical duty, and in some cases it may rise to your legal duty if it meets one of these definitions. Also with sexual abuse, if you know a colleague is engaged in a relationship with a current client, you must report that. That is sexual abuse, regardless of whether they say it's consensual or the client consent does not exist in that situation. If it is a former client, you should report that as well. It's not always sexual abuse, but it is sometimes, depending on whether the vulnerability inherent in the therapeutic client relationship is still found to exist, and that would be an abuse of that power and trust. And that is up for the college through its ICRC, Increased Complaints and Reports Committee, and Discipline Committee to assess. Also with sexual abuse reports, you need to know the name of the regulated health professional who have alleged to committed the abuse. Now, just because the patient doesn't know or doesn't want to tell you, or you can't get a hold of the patient again to find out, doesn't mean you just throw up your hands and say, oh, well, I guess I can't report. You do need to make efforts to find out and contact the college, contact this college or the college of the relevant regulated health professional and see if they can help you with the identity. It's never a reason, you know, when you're aware that sexual abuse may have happened, you really need to take this serious and not look for a way out of reporting it. You do not provide the name of the patient unless the patient consents. But again, if the patient doesn't consent, if a patient you see very often and you ask them, you tell them, I have to make a report about this, and they say no, you are still obligated to make the report, you just don't put their name in. The college will attempt to get the consent from the client, and we have people that are trained in these sensitive type matters to do so. Oftentimes a client just needs time, and needs a lot of time in some cases, to process the event and also to understand the college's process. And then lastly, you need to file the report in writing to the registrar within 30 days of discovery or sooner, and I would recommend that you do it as soon as possible. This is not something that if you find out on a Tuesday, you wait until Friday afternoon when you're not seeing other clients. This is something that you need to act on right away. And probably the first thing you can do is call the college and find out more. Reports of termination or dissolution. So dissolution I'm not going to get in as much to, but it's fairly similar to termination. Reports of termination, you need to report that when it's related to misconduct, incompetence, or incapacity. This is not to be mixed up with the terms termination with cause or without cause. These are terms used in the employment law realm, and they are not quite the same as in the regulatory realm. Lots of times an employer will terminate someone without cause because it's much easier and quicker, and they just pay them out and they don't have to deal with it anymore. But there was a reason behind that ultimate termination that needs to be reported. What doesn't need to be reported are terminations for reason of redundancy, cutbacks, or other systems issues. Other important points to remember about mandatory reports: they need to be in writing. They are filed with the registrar, so you address them to the registrar. They should identify yourself in the report and, you know, lay out, you don't have to write a 10-page story, but just lay out the issue and perhaps some of the dates and times of if there were actual incidents. So if there was an incident of abuse, the date that happened, and any other relevant details. If it's not sexual abuse, you can put the relevant client names in the report. So it doesn't have to be pages and pages, but do try to get the really those types of exact details in there as fast as you can so that they are able to be recalled later on. For reporters, you do have protection for reporting in good faith, and this basically means that, you know, if you make a report about someone, that person can't turn around and sue you, even if the college decides to not take any regulatory action, or they do, but then the ICRC decides to take no further action. As long as it was made in good faith or under your mandatory reporting duty, then you can feel safe that you're protected. It is professional misconduct for failure to report. And your identity is not guaranteed to be confidential. Measures can be put in place if there is risk of harm to the reporter. But please note that risk of harm doesn't mean you feel uncomfortable at work, or you might, you know, suffer a little bit of alienation, stress. Maybe the person you're reporting was a professional friend and they're not going to be your friend anymore. That's not a risk of harm. You know, risk of harm is if there's an actual threat. It is very rare. Sometimes there's some intimidation, but normally that intimidation is aimed at just getting people not to file the report. Once the report is filed, you've kind of called the person's bluff, and they will be more concerned with the regulatory action that may be the fallout than going after someone who really all they did was just file the report. They had no say. You have no say in what the college does with that report. There are mandatory reports required required under other legislation, and I'm not going to get into detail into those because they're not reports that the college would assess. But just to be aware, the most obvious are reporting child abuse, elder abuse, or risk of harm. So note where you practice, and if you work in long-term care, elder abuse might be obviously a bigger issue that you need to be aware of and what you would need to do in those situations. And you can always call the college, or you can call the relevant organization for further clarification. Okay, so actually the last thing I would say on other important points are when it's a mandatory report and it's an obvious mandatory report, it's mandatory, we have to make the report. There's some reports that may not quite rise up to the mandatory level, because remember, mandatory are the most extreme things. But when in doubt, I always like to tell practitioners, when in doubt, report. Again, because if you report in good faith, you don't need to worry about being sued. And that's the end of your duty. You report. You provide it in writing, you provide the necessary details, and that's it. You are not a party in the way that a complainant is in the complaints process. You're not part of the decision making in what the college, how the college proceeds, and you won't be kept apprised of the matter. So all you have to do is provide the information. You may become a witness during the investigation. You may be required to give other information, and that you would be required to, but there's no other role for you. You don't have to be involved in perhaps uncomfortable decision making around what to do with the report. So once we receive a report, all reports are reviewed by the registrar and other relevant staff. So that would most notably be myself, and perhaps one or two other people if we just want some extra input to make sure that we are proceeding in the right way. Where the registrar has reasonable and probable grounds to believe that a member has committed an act of professional misconduct, is incompetent, or is incapacitated, the registrar will initiate an investigation. So important to note here that at this first step, where it says assessment by registrar, there is no risk of losing your license. This is just an assessment phase. The only exception to that is if the registrar calls on the Increased Complaints and Reports Committee to issue an emergency appointment of investigator and then issue an emergency interim suspension. Those powers are quite draconian, and they're reserved for the most serious of cases. So I did a case back at my old college where we received a report from the police where the member had just the night before been charged with sexual assault, serious sexual assault of a patient who was also a minor. So that's almost about as most serious as you can think about, and we had to act on that immediately. It was a very, very serious matter. But generally speaking, you will not face any kind of threat to your license at this phase. So once an investigation is initiated, an investigation will look into the various incidents or issues that have been identified by the registrar through the use of that report and maybe some very cursory calls to the reporter just to find out maybe if there were more information. It's not a fishing expedition. So an investigator who is appointed to investigate is not going to come in and search everything in your practice and everything in your life. There do have to be some parameters around that. This is the stage where, as a reporter, you would likely be contacted again as a witness, and you may be asked to provide additional details or just help with the investigation. So if you're a manager, you might be aware of what other colleagues might be relevant witnesses, or help make the charts accessible to an investigator who needs to review the records. Once the investigation is complete, it will be reviewed by the ICRC, and their basic determination is to decide whether or not something needs to be referred to discipline or the fitness to practice committee. And if they don't decide that and referral is for high-risk cases that pose a risk to the public, and that they don't believe any remedial action is strong enough. If they don't refer, then they can take other action that is remedial, or they take no action at all. But I will note that because mandatory reports by design are meant to capture high-risk behavior, a vast majority of these mandatory reports will at the very least be investigated. And so for more, you can look at the complaints process guide online, which explains more about the ICRC processes and mandate. There are a few differences with how reports are dealt with, but it will give you an idea of how the ICRC makes decisions and the discipline process as well. Okay, so now we're going to switch gears a little bit, well, kind of a little bit. We're just going to start to transition into the other part of the presentation. First, we will talk about findings of guilt. Now, we use the term findings of guilt because it's actually a bit of a broader definition than the word conviction, but I'll use them interchangeably for this presentation because people kind of understand the word conviction a little bit more readily. So first of all, we need to understand that findings of guilt, which are relevant to the suitability to practice, is professional misconduct under the Regulated Health Professions Act. So this is a provision of misconduct for every regulated health profession in Ontario, and every profession has the same mandatory duty. So this is not just the College of Kinesiologists. So it is important that members understand the full breadth of this reporting, their reporting duties. So while only offenses that are relevant to the suitability of practice are professional misconduct, you are required to report all offenses. So that includes any federal or provincial offenses and any criminal offenses in any jurisdiction. So it may seem very obvious that parking tickets or something along those lines are not an issue of risk the regulator would address, but every finding or conviction must be reported. It is the job of the regulator to assess which will be addressed, as it is our mandate to protect the public, and we do everything through that lens. And the reason that the mandatory reporting duty is likely so broad is because it may be a slippery slope to allow members to self-assess, because I think very understandably and very naturally, there will be an inclination to minimize a finding or rationalize that it is not a matter of public interest. So yeah, we can all say that parking tickets are fairly non-serious, but someone else might think, well, my conviction for dangerous driving isn't serious, or my conviction for assault isn't serious, or my murder conviction isn't serious. There will be people out there that will want to make that assessment on their own, and it's not you that makes the assessment. It's the college through the ICRC and the discipline who's acting in the public interest to make that decision on behalf of the public. So when a self-report of conviction is received, it will go through the process that I just described. So it will go through, and if the registrar sees a conviction for a parking ticket, they're not going to investigate. You know, I can almost 100% guarantee you of that. I can't think of a situation where it would be, but I never like to speak in absolutes. That's a lawyer thing. But a conviction murder would likely be investigated to see if it is relevant to the suitability of practice. So this is the process that has existed for many years. It's not new, and it will continue to happen for the very foreseeable future. Okay, so as I said, not every conviction will be found to also be professional misconduct, only those convictions that are relevant to the suitability of practice. So you're probably asking yourself, what's relevant to the suitability of practice? Well, we do know that there's a requirement of good character to get into the profession. There is a requirement of good character to stay in the profession. And generally we think of characteristics such as honesty, integrity, accountability, respect as being characteristics of someone who is a regulated health professional. So some offenses reflect a lack of these characteristics. They may not reflect an immediate risk of harm to patients or clients, but that they just reflect this idea that you're not upholding your profession. So relevant to suitability can be a very broad concept. And it's also about trust and confidence in the profession. So first of all, with respect to trust, trust is a cornerstone of the therapeutic client relationship, which is the trust between an individual patient client and the practitioner. So even a competent client or even a competent practitioner may not be able to obtain good health outcomes if they don't have the trust of the client. And then there is the trust on the broad level between the public and the profession. So remember we spoke about that reputation. If there's a bit of a reputation out there that, you know, I'm going to take a crazy example that kinesiologists are murderers, which I know you're not. People may not, on the broad level, people just may not come to seek a kinesiologist at all. Through our consultation, one person commented that only criminal offenses involving clients should be considered relevant, but this really doesn't reflect the idea of professionalism. There are some offenses that would affect the integrity and respect of that individual and the profession as a whole. So for example, there was a case at another college that went to a discipline hearing, and it was a case of, it was convicted of, I think it was conspiracy to commit first-degree murder. I don't know if the murder was actually committed, but anyways, it was very serious. It was first-degree murder. And this person was found guilty, so it's a finding, it's a conviction. And the member tried to argue that it wasn't relevant because it was his wife, and that's a private matter between a husband and a wife. Well, maybe it is, but it's also a matter for society, so why it went to criminal court. And the discipline committee in that case rejected that argument very promptly because it was just such a serious crime and it was violent in nature. And for a lot of professions, they have this idea that in a health profession, which are often caring professions, you can't cause harm. So even in your outside personal life behavior, you should not be causing harm. So just to stress that relevancy can be a very wide net. So think about yourself as a kinesiologist and in this new profession. Who do you want your colleagues to be? Because they will represent you as much as you represent yourself. And the quote on the bottom here, professionalism requires a higher standard of behavior. That was actually someone who put that on the consultation, and I really just think it summarizes perfectly what the public expects of the profession and also what the profession should expect of itself. So that's very, very important to remember. These are not just, it's not just offenses or convictions for offenses that involve clients. It's really this broader idea. Okay, so, you know, despite the fact that I said relevancy to practice is a broad concept, you're probably still asking yourself, well, what the heck does it mean? Because there are a lot of gray areas and there are thousands of offenses out there. So as I said, while you have a duty to report all the findings, regardless of the apparent seriousness of them, the regulator has the duty to assess whether it may be relevant to suitability. This assessment is carried out through a number of stages described in that process that I showed you before. And then it is decided ultimately in a conclusive way at a discipline hearing. Likely, most, if not all, criminal offenses would be considered relevant. Now, not all criminal offenses are the same. There is a range of seriousness within the criminal code, but our criminal code reflects our values as a society. And the offenses that are listed in there are listed in there for a reason. Now, society does change, and some offenses have been taken out over the years. I mean, if you look at the criminal code 50 years ago, there's some offenses in there that would probably shock most people now. And there's things do change. So if we look at marijuana, possession of marijuana, that's being decriminalized. It may even be legalized. So, we will keep abreast of those, but there's a lot of offenses that are going to stay there for the very near future. And also, what makes an offense a criminal offense is that there always has to be intent. So this is not something that you do accidentally. Now, what would almost be never considered relevant is, minor municipal offenses such as parking tickets or turning right on a red light, or there's others under other acts like trespassing or fishing out of season is another offense. So there are tons and tons of offenses. So therefore, it's often known what is clearly relevant, and it's often known what is clearly irrelevant. But there are thousands of offenses in between that will require assessment. And again, a lot of people have been asking, well, still, what is relevant and how will this be determined? There will be some policy development on this, and all of our policies are made public. But if we look at that slide that we looked at before, the one just before this, I talked about some of those characteristics. And these will be factors that are considered when we assess reports of conviction. So did it involve clients? Did it involve violence? Did it involve a breach of trust or significant dishonesty? Is it a repetitive behavior demonstrating a disregard for rules? So you may file one conviction and there's no regulatory action initiated, but maybe a couple more come in, or maybe some other people report other issues. So we do have a history of members that maybe sometimes one doesn't look so bad, but 5 is a different story. Or other offenses where there's a risk of harm to others. So while may not be an intentful harm like assault or murder, but something like where it's dangerous driving, you've been road racing. You're not meaning to cause harm, but it's clearly a very risky behavior. Some people asked whether we will be making a list of what is relevant and what is not. And this won't happen. There's just way too many offenses to do so, and it doesn't allow for the flexibility to respond to, possibly the myriad of individual cases that we'll get. But those are the things that we will be considering. Those are the factors. Okay, so the next slide, we're going to start getting into the new bylaw, which is being circulated right now for consultation. And I just want to reiterate here that this bylaw and this reporting duty applies to convictions, findings of guilt, not charges, okay? So it's been something that has already been proven in a court of law. So the new bylaw proposal states that the registrar will be able to make public any findings of guilt in respect of a federal or provincial offense or a criminal offense in any other jurisdiction that the registrar believes is relevant to the member's suitability to practice. This will include the date and a brief summary of the finding, the date of and the sentence imposed, and if any, where the finding is under appeal, a notation to that effect. So if you are convicted but you appeal, you must still file the report of the conviction, but you let us know that it's under appeal, and there will be that notation. If you're successful on appeal, the conviction comes down. So what this bylaw does, essentially, is it allows the fact of the conviction to be posted at the time the regulator becomes aware of it. Only a summary of the conviction will be posted. It is not a posting of professional misconduct as found by the regulator. That process will still be going on as I described, and only a discipline panel can make a finding of professional misconduct. And the process that I just described is already in place with respect to assessing the relevance to suitability. It's already being assessed at many stages, and then it's determined conclusively at discipline. So from the diagram, you can see that this new bylaw creates more of an offshoot of an existing process, and that is where the registrar has when the registrar has reasonable and probable grounds to investigate a finding of guilt for potential misconduct, he or she also has the authority to post the fact of the conviction on the public register. So what needs to be highlighted is under the existing process, there can be several months, sometimes up to a year, before a referral is made to discipline. And this is the first time the public would have some indication of possible misconduct on the part of the member. Yet information about a conviction may be very pertinent in the public's right to choose their healthcare practitioners. While their immediate safety may not be at risk, the public has a right to choose someone whom they believe to be trustworthy and ethical, and some offenses, some conviction for offenses, may lead people to think otherwise. Now, one of the questions in the consultation so far has been around the decision-making power centered in the registrar, and maybe some fear that this is one person making arbitrary decisions. However, I do want to allay your fears that this will be a collaborative effort. Myself and other relevant staff will be very heavily involved in the consultation with the registrar, as well as we will seek out opinions of other regulators who may have dealt with a similar type case. And in some cases, we will seek legal counsel advice, because some of the lawyers in this field advise several regulators, and they have a broader view across the spectrum of colleges, whereas people in colleges often only know their day-to-day operations. Also, with respect to this decision-making in the registrar has to have reasonable belief. So it's not an absolute belief. She doesn't have to know that the offense is relevant, but has to have an idea that it may be, and that there's a risk involved in the public not knowing this information. And the word reasonable implies that there has to be objective reasoning. It's not just based on the registrar's own personal beliefs or values, and it's not based on any kind of other information they might have about that member. It's on the offense. Further, the registrar will have to write to the member indicating the decision to post, and members will be given an opportunity to respond. However, in all cases where the registrar will be posting a conviction, an investigation will also be initiated, because if you have reasonable and probable grounds to believe an offense is relevant to suitability so that you can post it, you're naturally going to have reasonable and probable grounds to believe that professional misconduct has been committed. And then the member will be having a chance to, or opportunity to respond to the ICRC. Another question on the consultation is, are other regulators doing this? And the answer is yes. All regulators have been asked to examine their practice in terms of transparency by the government. And moreover, nurses, doctors, dentists, physiotherapists, optometrists, and pharmacists have already passed this bylaw, and many others relating to more information being public. And other colleges are, in different stages of this process. But this is one bylaw that is definitely moving forward. It's important to remember that this information is already public. And we are following closely with other regulators because one of the transparency principles is consistency. So the public needs to trust that they will get similar relevant information from all regulators about practitioners. Okay, so how this new bylaw and transparency. And this little graphic, I like to think of it as if that hand holding is that brush. Think of that as the client who wants to choose someone to seek healthcare from and wants to know that they can trust that practitioner. And sometimes they may not feel like, when you look how much clearer you can see when you wipe away and you're able to see what the college's processes are with respect to their practitioners. So it's important to remember with respect to this bylaw that convictions are already public information, but that transparency is more than just about posting information, but it's about making pertinent information about a member accessible, relevant, understandable, and timely. A member of the public is likely going to check the public register for information about a member than to search the court for any convictions, and that would be an incredibly onerous task. So relevant information about a member or practitioner must be found in the most relevant place. I also want to add for members to think of transparency as not just a concern of the regulator, but a concern for the profession itself. It's part of self-governing, that you don't have your self-interest, just your self-interest in mind, but that you yourself in your everyday practice are operating in the public interest, and that you have the concern of the public at heart. And if you consider some of the standards of practice that you have to abide by every day, they are centered a lot around public interest and transparency. So you have a duty to provide care, a duty not to discontinue services without, making sure the person will be okay. Transparency in billing requirements, full disclosure with respect to conflicts of interest, and full disclosure regarding the risks and benefits of a proposed treatment when you obtain consent. And another element of being a self-regulated profession is that because there's this theory that you are somewhat, you are giving up a little bit of your private interest and acting in the public good. When you choose to serve the public interest, you do give up a little bit of your privacy. The public is choosing to seek health care, and it's not just a treatment that may pose a risk, but the practitioner. So the public needs the necessary amount of information to make the choices that are best for them. And we are all about client choice in our healthcare community in Ontario. So you do have a right to privacy, but this has to be balanced with what the public needs to know. Our transparency principles are available on the website, and this is just the first of many upcoming bylaw proposals to make more information about members, kinesiologists, public. So these principles will be important to help you understand why these changes are coming. And generally, our society is always pushing for more information and more accountability. One of the big things to remember when you're thinking about this bylaw and bylaws to come is to remember the patient's perspective and not just your own. Think about what you might want to know if you are seeing a practitioner, or what you'd want a family member to know if they were going to see a practitioner. And that's everywhere, anyone from a kinesiologist to a chiropodist to a physiotherapist to a doctor or a nurse. Think about it in your own life. Where have you benefited from increased access to information, or where have you felt vulnerable because you didn't feel you had all the facts? And another important thing to point out is that healthcare practitioners often do have a lot more information about the other healthcare practitioners in their community, in their immediate workplace, in their own profession. And they might be making choices for themselves or friends or family members. You refer to someone you know because you know a lot about that person's day-to-day practice that the other public may not know, because it's not necessarily a discipline finding for a college, but it did affect the choice that you made to seek somebody over another. And I think a lot of people forget that they are privy to a lot of information that some people are not. And is that information relevant? And the last thing I'll say before we can have some time for questions is the college is, it's always, again, to remember that the college is mandated to reduce the risk to the public, to protect the public. And this is a higher mandate than protecting the privacy of members. And in fact, we are not here to protect members. We are here to be fair to you when you may become engaged in our processes. But where there is a risk to the public, then privacy cannot always be preserved. And now increased transparency, meaning more information about members, is the reality that colleges and the professions are facing. So it is important to keep this patient's perspective in mind, and to also think of this as an opportunity for you to increase the confidence in this profession as a whole. So I know that it can be, there's a lot of anxiety around having more information about members made public, but this is the environment that we are in, and I don't think it's necessarily all doom and gloom, and it can be quite an opportunity for a new profession to show themselves to be professionals. So are there any questions? Please feel free to type them in. Um, there's always a lot of questions about parking tickets. Um, I know a lot of people are thinking, oh my gosh, I have to report parking tickets. You do. We're not going out to look at that information, but it is something that has to be reported. And I explained that, yes, while we can probably all agree that parking tickets are not relevant to the suitability of practice, once you give that discretion to the individuals, then what's to say that they may not think, oh, well, my conviction for dangerous driving isn't relevant, or my conviction for assault isn't relevant, or my conviction for murder isn't relevant. And I'm pretty sure in that case that I mentioned to you about the first-degree murder, I don't think it was the member that reported it, as is often the case, and then they always get nailed at discipline for failing to report as well. So in that case, that person, maybe they didn't report because they wanted to try to get away with murder, pardon the pun, but maybe they did actually try to justify to themselves that it wasn't relevant to the regulator. So I know it's extreme, but we do know that there are people out there that would try to hide something. So yes, it includes everything. And annual reporting will be coming up. There will be a spot for everybody to report any changes in the last year. Okay, there's a question about divorce. Divorce is not a finding of guilt. It's just it's a different type of proceeding. Would not be defined as a finding of guilt. So you don't need to report that you got divorced. If you got convicted of assault against your spouse, that you need to report. Sorry, we're just reading the questions here. So there's a question about a finding, looks like if you have findings to do with taxes. So the Income Tax Act is a federal act, and there are offenses under that Income Tax Act. I can't remember all of them, but some of them might be falsifying a tax return. I'm not sure if that's criminal or if it's tax act. There are some federal offenses that are quite serious and could almost rise to criminal offenses. But yes, that if there's a finding, that has to be reported. And again, we would look at the factors, and it will be assessed through all the different processes, and you will have opportunities to respond and to explain the context. And we will be fair to members, but we will be doing everything through the public interest. So again, all findings of guilt must be reported. If you have any offenses, if you have any findings of guilt that weren't criminal offenses from before the college existed, no, you don't have to report those to us now. And for most of you, you would have provided a criminal record check, so we would know if anyone had criminal convictions as of the date you registered. So no, you don't need to worry about the years past. Someone's asking a question about reporting if you have a mental health issue. There is no self-report to report your, so there is the issue of incapacity, and incapacity doesn't mean that you have, the definition of incapacity is not just that you have a mental disorder or physical disorder or dysfunction, but that it affects your ability to practice. So someone who has a depression but is managing it, it may not affect their practice, and it may not be that may not affect your license. There is not a duty to report yourself for incapacity. Likely people wouldn't, but there is a duty for people to report incapacity by employers and facility operators, as I mentioned. But again, that incapacity has to rise to the level of posing a risk to the public because the practice is being affected. There's a good question here. Do we have to let you know if there's a bankruptcy? Again, I do not believe bankruptcy is a finding. I'd have to look up the, can't remember the act. But you will know if you have a finding. It will, you'll have a piece of paper or a certificate that says there's been a finding of guilt. But I know it isn't, because you're not really guilty of bankruptcy. Bankruptcy is often something that happens. I know, actually, being a lawyer, that is something that we do have to prove, but that's because we're dealing with money and trust for lawyers who are practicing with clients. They're often holding money in trust, so bankruptcy is relevant, but not for healthcare professionals. Okay. Again, we're getting questions regarding parking tickets. So it is a bit of a weird thing. They are municipal offenses, but the administration of them is done by the municipality, but they are still provincial offenses. It gets a bit confusing, and I don't want to get into the whole legal structure of it, but they do need to be reported. I don't want the focus here to be on parking tickets, okay? It's about understanding why there is a mandatory duty to report, and all you have to do is just report it, and we'll do the rest. If there are questions that we look at that we haven't answered, or people ask me questions afterwards, we will post a FAQ in the coming weeks. With respect to the new bylaw, because there's a consultation out until the 26th of May, and then it goes back to council, we will likely be publishing some type of document to answer those questions and explain any outcomes of the council meeting with respect to that bylaw taking effect. Okay, so we're at 7:58, so probably a pretty good time to sign off. Again, please feel free, my contact details are up there on the slide, to call me or email me with any questions that you haven't thought of here. And I want to thank everybody for attending tonight and listening to this lovely subject of mandatory reporting. But it is important, and I do want to, while it seems not the most positive of subjects, you're having to report bad things. I think it's really important for the profession to see this as an opportunity to be recognized as a respectful profession with integrity, honesty, accountability, etc. Okay, so have a good night, everybody. Thank you.